I am Fiona Ma. I'm the chair of the Domestic Violence Select Committee, and I've been the chair for the last 5 years, and I've had an opportunity to work with many people who are here in the audience today. This is an issue that I feel very passionately about. I had the opportunity to meet Brenda and Olivia, who did Sin by Silence, and I felt we needed to do something here at the state level. I know that then Assemblymember Jackie Speier also felt passionately about this issue and passed a law in 1992 that allowed some of the women who were incarcerated to have a second chance for justice. Some of them are here today, and we're going to talk about that. But there are still about 50 women still in jail today that were convicted prior to 1992 that don't have an opportunity to have their cases heard because either there was no paperwork filed, they didn't file a restraining order, they didn't go to the hospital, and so and some of them, I guess, they're just old paperwork. The witnesses are no longer here to provide those type of testimonies. So we're going to hear a lot about that today, and these women are not ordinary women. These women acted out of distress, out of self-defense, and imminent danger. And we are going to hear that. And so we are looking not only to hear their stories, a little bit about what and how the system works today and what we can do to make it better and to give these 50 women who are sitting in jail, life without parole, an opportunity to have their cases heard. My colleague is here, Dr. Richard Pan. He is a member of the Domestic Violence Select Committee. I'm going to offer him the opportunity to say something in a minute. We are going to take public comment after all of the panelists. So if you would like to provide public comment, if you could come up and sign in, and then we will take you in order at the end of the formal panelist section. So without further ado, Dr. Pan.
Well, thank you so much, and again for your leadership in bringing this together. And I also want to thank the courage of the witnesses to come forth, because I know this is a very difficult thing to talk about publicly. And so I very much look forward to hearing the testimony. And again, thank you for your leadership.
Thank you. And I also like to thank my staff who have been working very hard on this issue, this hearing today, as well as on this issue. Gina Frisbee is here in the Capitol office, and Genevieve Japanda works in my district office. So I want to thank them for their hard work. So will the first two panelists please come up, Brenda Klubine and Flozell Woodmore. These are two formerly incarcerated women who are going to share their stories. You sit there, Brenda. Flozell, you sit there, and then you press the button, and when the light comes on, you are live. Okay.
It is an honor for me to be here. I'm not an actor. I am a formerly incarcerated survivor. I'm here because I was forced to make a decision almost 30 years ago now that changed my life for over 26 years. And because of that, and because of many things that followed, I have had to leave many of my sisters behind that are still incarcerated, that have fallen through the cracks. I met my husband and I thought he was such a wonderful man. He opened the door for me. He treated me like a princess. And all of a sudden, all of those same reasons that he called me wonderful things, he called me horrible names. He started isolating me from everyone. He wanted me to quit my job. But what I didn't know then was that those were warning signs. I didn't get that, when he'd get overly excited and get angry over a parking spot, that it was so much bigger than that. That I needed to pay attention. I didn't know. It wasn't that I was stupid. I just didn't know. I reached out to the police. I reached out to friends until there was nobody left. I had report after report after report only to be told that he's no longer here, there's nothing we can do, or they'd yuck it up in the driveway and they'd go on about their business. Or better yet, I'd be standing next to him and they'd say, "Did he hit you?" And I'd go, because I didn't want to say anything out loud. And in one night, all because I wanted a divorce after things had escalated so much and the calls just kept getting more and more frequent to the police department, I agreed to meet with my husband at a public place, in a public restaurant, to have dinner, just to get things done. And it was the mistake of my life. I didn't realize, after pressing charges on yet one more physical instance between us, where my husband had fractured my skull and basically left me for dead, that he wanted it that way. He wanted me to go back with him into a situation where I would be alone. And I didn't know that. Although my intuition was telling me then, I didn't know. And so I went upstairs with him that night, and things got progressively worse. And I had to protect myself by hitting my husband over the head with a wine bottle. And things changed for the next 26 years. I went to trial twice. I was ultimately charged with first-degree murder. And I was thrown into a justice system that didn't get it. They didn't understand that after a series of events, you know, when something happens, it's different. You know that it's different that night. I knew then that it was different. When he asked me for my wedding rings, I knew it was different. Tomorrow they won't be able to identify you. I know it's different. What do you say to somebody that has to go through that unless you've been there yourself? All you can say is, I hope you can understand and hear what I'm saying when I'm saying that it just happened. And then when I was thrown to a system that didn't get it because there was no battered women syndrome admissibility law, and there was nothing until years later, thanks to Convicted Women Against Abuse, what do? I ended up starting the first abuse group for women in prison in the nation, called Convicted Women Against Abuse, at the California Institution for Women. Many of my sisters are still there. The same ones that were there when I first got there are still imprisoned there today because they didn't have the hospital records. They didn't have the eyewitnesses. They didn't have the police reports that I had. You know, they didn't call a shelter to be turned away like I did. They didn't have those things. So what are they just supposed to be there? Are they supposed to die in prison because nobody wants to hear them? We have to give them a voice today. We have to tell them that, you know what, they do matter because they're stuck. And you know what? They've given back in a way that is so huge. They were part of a project called Sin by Silence that they wanted to be able to educate the public about what they went through so that nobody else lives the nightmare that they've lived. And by doing this, they have touched millions of lives. And it matters to them. You know, they don't know. They really don't have a clue how many people that they've touched. What matters to them is that they're doing something to be a part of breaking the silence and making the difference. That's all that matters to them. They don't want to be thought as worthless human beings because they're in prison. They want someone to know that they're willing to give back too. That's what I do every day. I just had my 3rd anniversary of being out on October 22nd of this year. I've started a nonprofit called Every 9 Seconds, and I'm proud to say that I'm part of Sin by Silence, that we've partnered together, and together we all break that silence. Let's be part of giving these women a voice and help them have the chance to come home. They deserve it. They've worked hard to make changes and mentor their peers. Nobody wants to be exonerated for what they did. Nobody wants someone to say what happened was good. I'm not asking for anyone to applaud anything. I just want someone to hear me and say that, you know what? It can happen to anyone. To your daughter, to your wife, to your mother, and to your sister. Be prepared to listen because it's important.
Hi, my name is Flozell Woodmore, and I am here to share my story as well as explain the evidence of people in situation as mine still in need of our assistance. At 13 years old, I got involved in a relationship that soon became extremely violent. My boyfriend was 19 at the time. For 5 years, I was made to, he forced me to have sex with him. He forced me to get abortions against my morals twice, threw me downstairs, knocked me out. It is still hard for me to talk about today, but I will talk about it to help those that I know has trudged that road that I've traveled, suffering abuse. One night, my boyfriend jumped on me, and our then 2-year-old son was trying to stop him. He grabbed my son by the neck and slammed him against the wall. Now, I suffered abuse at his hands for 5 years, and never did it ever cross my mind to fight him back. But when I saw my son flying against that wall, I had to try to stop him. I started fighting him back. So me and my 2-year-old son was swinging at him with all our might. I finally managed to get away. I got my purse and came back, which had my stepfather's gun in it from my mom and my stepfather fighting. I called myself hiding that weapon from them. It happened to be the weapon I used to take my boyfriend's life. At that time, I was 18 years old. Never had a criminal history a day in my life. Straight A student. Planned to join the Navy. All that was taken from me that night. Upon being arrested, I was too assured that I would be okay because I didn't have a criminal record. He was a menace to society, blah, blah, blah. All these words I heard, but they went through one ear and out the other because my main concern was, where's my baby? What's going to happen to me? I was terrified. Living in South Central Los Angeles, as you already know, is riddled with violence. And to me, being abused by your boyfriend was normal. I didn't see nothing wrong with it. But at some point, I wanted out. And I didn't know how to do that. I had no one to turn to. Everybody I knew, brother, sister, mother, father, grandmother, great-grandmother, everybody had been subjected to violence. And everyone say, oh, it'll be okay. Clean yourself up and go to school. How do you tell a 14-year-old clean herself up from just being made to have an abortion? Go to school. I went to school. And I seen this program that said they help women. So I went and knocked on the door, wanting to know if they could help me. I knew I needed help, even at 14 years old. And them people said they couldn't help me. And the reason being was because I was too young, and they sent me away. And I believe that if they had been able to help me, I would have never went to prison. At least not for no 20 years. Upon being charged, experienced a preliminary hearing, I discovered that there was nothing that had happened the courts would allow. I had my entire community willing to come testify for me. But because domestic violence was not considered a law and not allowed in court, no one was able to testify. There wasn't even no reports taken to be documented along with my sentencing transcripts. That's how much no one knew about domestic violence in the 80s. I had no clue what I was going into. I had no clue what was going on. I was scared to death. Going into a place that I didn't even know exist for women. Nevertheless, I get there. I immediately get involved with what needs to be done for me to better my education. I knew at some point that I needed to learn what had happened to me and how can I help prevent it from happening to others. At which time I met Brenda Klubine, who has started the CWAA. Thank you, Brenda. I knew at that point that my life would be saved. So we sit before you today because the issue was I still a threat to society? In 1992, the 1473.5 was passed. And it wasn't until 2002, I was found suitable for parole because of that bill. I had to endure 6 parole grants. I was granted parole 6 times, back to back, by the parole board based on the investigations and testimonies regarding my case. And each time the governor reversed, saying that there was not enough evidence. So the board of parole investigated my case 3 more times. And each time they found more evidence in favor of my being a sufferer of domestic violence. So finally, Arnold Schwarzenegger signed my release. Nevertheless, throughout that battle, the question was I or was I not still a threat to society? The parole board said no, I wasn't. The governor said yes, I was. Overall, I was released. And here's where the answer to that question took place. Because I knew I was not a threat. I wasn't a threat then. I was a threat to the danger of my life at that time. But to answer that question, I am now. I started out as administrative assistant at a program called the New Way of Life Reentry Project for women and girls transitioning back into society after incarceration. I am now the assistant director of that program and training to be the executive director of that program. We have 5 homes that assist women and their children. I am also a current Searles Justice Fellow, and I am also a finalist for Citizen Against Recidivism Award. And I have not stopped there. We also assist people who have old criminal history that interferes with their employment. So we also help them get expungements for free. Everything we do is for free. Rent is based on their income. And these are things that did not exist during the time of my suffers. However, we've helped over 500 women get their lives back together. And I imagine this is something I'll be doing for the rest of my life. Nevertheless, I have a letter here from Anna Gillinetz, and she is me. She is me, and at some point I would like to share the words I shared years ago with society that she is sharing today. Thank you.
I would like to say one more thing, and that is that I'm sitting here before you today because of 1473.5 going into effect. The parole board let me down. Time and time again, they kept saying that I was an unpredictable threat to society. 17 days before I was in the Los Angeles County Court, due to 1473.5, I was still found to be an unpredictable threat to society and denied parole yet again. Now, 1473.5 worked for me because I had all the documentation that it took to make that happen. I was 20 years old when I was arrested. I was 47 ultimately when I got out. That was over half of my life. I didn't even know how to use a cell phone Something as simple as that. You know, those commercials on TV, they say, they don't show you how to use them. Thanks to programs that Flazell works with today, these women have a chance to have those kinds of things, to be able to learn how to do these things. 1473.5 is great, but there are cracks, and it's the women that fall through those cracks that we're talking about today. I had a chance. Flazell had a chance. Let's give them a chance. Let's continue to see where it's broken and what we can do to fix it. I am so honored to have had the chance today to be here and to be part of this process. Thank you so much.
Thank you, Brenda and Flozell. So we're going to have the panelists come up, and then at the end, if there are questions, we're going to bring you up. And I know that Flozell wants to read something at the end, and Brenda. So thank you very much, ladies, for your testimony, for coming up and sharing your stories with us. If we can ask Dr. Nancy Lemon and Judy Freeman. Dr. Nancy Lemon is a domestic violence law and clinical instructor at Boalt Hall School of Law in Berkeley. She's an expert witness and author of Domestic Violence Law. And Judy Freeman was the pro bono attorney for Brenda Klubine. Yes.
Hello, thank you for this opportunity to speak to all of you and to have this very, very important hearing. I'm Nancy Lemon. I have a law degree from Boalt Hall from 1980, and I've been teaching there since 1988 in domestic violence law and also running a practicum there on domestic violence. I've been an expert witness since 1994 in all kinds of areas, family law, torts, asylum, etc. Lots of criminal cases, both for prosecution and defense. And I was actually Flozell Woodmore's expert witness. I worked on 8 cases, including hers, that involve these types of habeas proceedings. And I want to say that I've met some really amazing and heroic women in the process of interviewing them for habeas petitions. I've been extremely moved by getting to do this work. But I want to back up a little bit and say a little bit about the 2 statutes that are most relevant. Both Brenda and Flozell were referring to 1473.5, and I also wanted to talk about Evidence Code 1107. The first one being the Evidence Code. That's our evidence code that talks about intimate partner battering and its effects. And it says that whenever it's relevant in any criminal proceeding, that it can be admitted. And so it's supposed to be looking at the beliefs, perceptions, and behaviors, well, both behaviors of abusers and then the responses to those behaviors by the victims of that abuse. And it's an excellent code section. We've had it in effect since 1992. It's been extremely useful in many types of cases, both for prosecution and for defense. And the expert is not actually diagnosing the person with any particular syndrome or post-traumatic stress disorder or anything like that. It's really looking at the patterns of behavior that are typical, and does this case fit those typical patterns. And then secondly, we have 1473.5, which Brenda talked about. That's in the Penal Code, and that specifically states that if you are convicted of a crime that's related to domestic violence and has to be a felony, but it does not have to be homicide. It could be other types of felonies as well. And if you are convicted before August of 1996, which is an important date because it was a state Supreme Court decision that came down that date, the Humphrey decision. And the third criteria is if you had no expert testimony at your trial on intimate partner battering and its effects or on domestic violence, then you are allowed to submit a habeas petition to the original court where you were convicted. So this could apply to people who never had a trial in the first place because they may have pled guilty, or people who were convicted after a trial. That's also been an extremely useful code section, and other people will talk about how many people have been able to get out because of that. But I wanted to say more about being an expert witness because I'm here today to talk about that part of my work, which is about half of the work that I'm doing. essentially, what expert witnesses do, as I said, is look at what are typical behaviors of batterers and victims, and does this case fit that? And very specifically, one of the things that we can do is talk to judges and juries or in written reports on what are the ways that this particular victim of domestic violence tried to access safety. We have this sort of assumption in our society that battered women don't do that they don't actually seek help. But in fact, it's quite typical for people to seek help. Flozell talked about when she was only 14 trying to seek help and being turned away. And that's unfortunately very typical. There's lots and lots of ways that people try to access safety, and they're often met with responses that don't help them. One example is in another case that I've worked on where we managed to get both two sisters who had been involved in the killing of one of those sisters' husbands. And I'm not going to use their names, but they're both out of prison now under 1473.5, and I was their expert witness for each separate case. In that case, the husband was a prison guard, and he said to the wife, "There's no point calling the police because I am the police." And they lived in a small town which was a prison town. And so she knew that that was actually true because all the other people in that town knew him and would support whatever he said. He was very abusive to her and to their 3 children. And at one point, the neighbors called CPS, and so CPS came to the house when the husband was not there and talked to the wife and her sister, and they said, "You have to get him out of this house because we hear he's abusing these children." But they didn't give her any way to do that. So the 2 sisters took all of their collective children and ran away. They drove far away to another part of the state where their family was from. And this man followed them with 2 guns. He always had 2 guns loaded on him at all times and threatened their lives and the lives of their children. And they went back because they had no idea what else to do. Eventually, they hired somebody to kill him. And they both went to prison, as did the man who actually killed this prison guard. We also talk as expert witnesses about the effects of the abuse on survivors of domestic violence. One of the main things that batterers do is to humiliate and degrade their victims. It's not just physical abuse, but there's lots and lots of emotional and mental and verbal abuse that's going on, often on a daily basis, whereas the physical is much less frequent. Usually it may be like every week or every month, but the emotional is very, very strong. And after many years of hearing that type of abusive language and being treated like dogs and so forth, it's very hard for many of the women to have the strength to know that they're worth having a good life. They start to believe that it's true, these things that are being told to them. And they're also told quite frequently that the husband or father will take the kids and they'll never see the kids again. And that CPS will give him the kids, or the family court will give him the kids, or he's got the money to hire the lawyer in the family court and she's never going to see these kids again and he's going to take them. And that is often a huge, huge threat for mothers. And most of the women that we deal with are mothers. There's a lot of these barriers to achieving safety, and I'm very concerned because what I see in our society is that even though we say we're opposed to domestic violence, we don't really act like it as much as we need to. And when we don't have those laws and procedures in place, then people are forced to fend for themselves, the women and their children. And specifically, for example, if the police are not enforcing restraining orders, which they often don't, we have a statute in California that mandates violation of restraining orders must result in arrest. That's often not followed. And we actually have a U.S. Supreme Court decision in the Gonzalez versus Castle Rock case in which the U.S. Supreme Court said a few years ago that there is actually no such right to enforcement of a restraining order, that's totally up to the police and it's discretionary and it doesn't really matter what the statutes say. I'm very concerned about that because that can lead to battered women feeling like they have no recourse but to kill their batterer if it gets to a really extreme situation. In addition, we are not giving people enough money to live off of on welfare. The welfare grants are very, very small. It's basically impossible to support kids off of that. And we're currently cutting welfare even more and cutting the family violence option, the special part that gives battered women extra time to be on welfare. Furthermore, we're cutting money sometimes from shelters and domestic violence agencies. Sometimes I'm seeing cases where prosecutors are not going forward, even though they have plenty of evidence without the victim participation, and they say, oh, you're not showing up, we're not going to go forward. I've also seen cases where children are taken away because their mother, quote, exposed them to domestic violence, when in fact it was the father or the mother's boyfriend who was the abuser, or giving joint custody or unsupervised visits to abusive dads. In all these types of situations, the legal system should be acting differently, and it's not, and it tends to leave people feeling like, I have no recourse except to just kill this guy. So what I want is for us as a society to really decide that we really are serious about ending domestic violence and providing people with what they need to accomplish that. Thank you.
I'm a member of the California State Bar, and for 4.5 years I was Brenda Klubine's attorney during the process of getting her writ granted and during her prior unsuccessful parole hearing. I'm really happy to be here today to work for the release of the rest of the incarcerated survivors who I really think deserve a chance to be represented and also to try to get their lives back and be back in the world. I want to speak about what it's like for a pro bono attorney to work on a case like this and try to explain why it's difficult to get representation for the rest of the incarcerated domestic violence survivors who might actually be eligible to be released. I first got involved in Brenda's case when I saw an article in the legal newspaper regarding the Habeas Project when it was first starting and asking for volunteer attorneys. When I read the article, I was surprised because the idea of women in prison for killing their abusers was something that was just not on my radar. I had always seen news stories and articles about women being killed by their partners after being stalked and beaten and so forth, but I really didn't have an idea that there were women who actually had been in prison for trying to defend themselves and do something to stop the violence. So when I volunteered with the Habeas Project, my intention was to do something good, but I had no idea that I was going to end up working for 4.5 years on a single case. But when I saw the notes of the interviews with Brenda in prison, I couldn't not get involved. Her case and the things that she went through really spoke to me. And just my sense of justice kind of required me to do it. So initially I was on a legal team, and almost immediately a couple of people had to drop out, and I never even met them. And then it was just me and one other attorney. And it's just really hard when you're working with volunteer attorneys. I mean, anything can come up. People have their own lives, they have their families, they have their jobs, and so it's really kind of hard to count on that. So I want to talk about some of the specific issues that make it difficult to actually do a case as a pro bono attorney. First of all, the time that's required is really kind of phenomenal. It's very time-consuming, both in terms of the day-to-day, what you're doing, and then in terms of how long the cases go on and so forth. And then really the volunteer attorneys have to do their own investigation of the cases. And this is something that I think most attorneys have never done or are not used to doing. Usually there are private investigators, but there's no money available. You can't just go out and hire them. They charge a lot of money. Actually, one investigator did do a little bit of pro bono work in Brenda's case, which I very much appreciated, but Mostly at the beginning, the other attorney who was still working on the case with me and I flew down to LA, and we were trying to find evidence in a case that was over 20 years old. So it's very difficult. Either the witnesses aren't there, they've moved away, they don't remember things, they don't really want to be talking about something that happened so long ago. And then in terms of the documentary evidence, I really always thought that important evidence would kind of be saved forever, somehow by, microfiche or something like that. And in fact, it's just dumped. And so, in Brenda's case, she had called the police many times. She had gone to her doctor. She had gone to the hospital emergency room when her husband had fractured her skull, and many things like that, and it was just really hard to get all of that evidence gathered together. And then another thing that makes it hard for pro bono attorneys is that there's a lot of travel involved. You have to travel to the prison to see your client, first of all, and the prisons are usually far away from where the attorney's working, and then you have to travel to other, to meetings with other attorneys and, as I said, to do the investigations and so forth. And then there are expenses that arise that really you have to pay out of pocket, because the Habeas Project tried to, give a few $100s to cover some expenses, but that is very quickly eaten up. And, just even things like having to Xerox, take things to Kinko's and Xerox stacks and stacks of papers and mailings and so forth, that it all, you have to end up paying for it. So, if a large firm takes on a pro bono case or somebody is appointed, there are resources there. But I think it's hard to consider that the women are going to be able to get very many pro bono attorneys who are sole practitioners or, have other kinds of jobs to be able to do it. I was lucky in that my circumstances allowed it, but not everybody's do. And then, as Brenda mentioned, I just want to bring up something about the parole process, which was, as she said, she went for another parole hearing after we'd already collected all the evidence, after we had all the material together for the petition for the writ of habeas corpus. We presented a case that ultimately was good enough for the court to release her, but she was denied parole. And I think part of that is there's just there's like a disconnect with the parole system, in that the commissioners don't really have a legal background. It's really hard. It's complicated. This is very complicated, and it's hard for them to kind of put it together and understand it. And I don't think there's probably enough training that goes on for the commissioners. So, Brenda and I left that hearing feeling very disheartened, because we knew that after so many times of her trying to be paroled, her best shot was the writ, and fortunately that was granted. So that's all I have to say, and thank you very much.
Judith, I do have a question. So you mentioned that the parole board members they don't have a legal background.
Well, most of them come from like a law enforcement background, but they're not attorneys. So in that sense, it's very different, to bring in all of this kind of evidence about battering, intimate partner battering and its effects and so forth, and kind of maybe expect that they're going to follow the ins and outs of the legalities of it.
Do you think it would help if the parole board members had a legal background?
I think that would help, and I think it would help if there was more training. And for example, another thing is that sometimes the commissioners that sit are not actually full commissioners; they're deputy commissioners. And those are just civil servants with very, they're like administrative employees with very little background that would relate to an understanding of this.
And those people, the deputies, are making the decisions?
Well, they're helping. There's usually two commissioners, unless things have changed since then, but there's two commissioners, and so one would be, I think there's supposed to be two full commissioners, but there aren't always enough people to go around because they're traveling all over the state. And so sometimes you will have a deputy commissioner come in, and they help make the decision.
There is also a requirement that the commissioners or deputy commissioners, I think, have training about domestic violence. And I think that Marissa Gonzalez can speak to that because I think she's done some of that training. But I believe that we need a lot more of that.
Okay, that's a great segue to the next panel. Thank you, ladies, very much.
Thank you very much.
Tara Shabazz, Director at the California Partnership to End Domestic Violence, Jean Jordan, California District Attorneys Association, and Marissa Gonzalez, Coordinator at the California Habeas Project. If you ladies could please come up. Okay, whoever's ready, please introduce yourself. Thank you.
Hello, my name is Tara Shabazz. I'm the Executive Director of the California Partnership to End Domestic Violence. And the partnership, we believe that by sharing expertise with legislators, and both legislators and advocates, we can work together to end domestic violence. We have a long track record of passing over 100 pieces of legislation on behalf of domestic violence survivors and their families. And thankfully, to the leadership of Nancy Lemon and Free Battered Women in Prison, we were able to help pass this unique law, which allows imprisoned formerly battered women to reopen their cases. From our work with survivors and domestic violence advocates across the state, we knew that hundreds of California women have been sentenced to jail time for involvement in their batter's death without anyone ever hearing about their abuse and how that relates to their crime. After being terrorized in their own homes by their abusers, these women are now being re-victimized by the criminal justice system that was, for all intent and purposes, blind to most important facts about their cases. Today, we know about the dynamics of abusive relationships and the effects of that trauma, depression, and chronic anxiety can have on victims over time. But 20 or more years ago, when many of these women were sentenced, we didn't understand how domestic violence related to their crimes. Most importantly, we did not have a support system that focused on protecting victims of domestic violence. And although there's still more work to be done, as we know that women today are still turned away from domestic violence service and shelters, either due to lack of funding or lack of resources. For women who have already served decades behind bars, it seems just that we revisit their cases in light of the new information we have and making sure we use all the wonderful advocacy tools we have in place. I feel very passionately about this issue because as a child, I grew up witnessing domestic violence in my home. I understand the psychological reality of a victim who lives in constant fear of their lives day after day. Acts of violence committed by a victim against a perpetrator are often different from other violent crimes. They're different because victims so often act in self-defense, out of desperation, or because they have been so worn down by the fear and the pain, and they feel like they have no choice. I know this because when I was 12, I chased after my mother's abuser with a knife. And I was fully intended on doing whatever I needed to do to protect my mother on that rainy night. And every day I sit and imagine what would have happened if I did not slip in the mud that night, and what would have happened if the police did not arrive that night. Where would I have ended up? What would my life have been like? I wasn't violent in any other ways, but the effect of watching my mother abused drove me to a point of desperation. I am fortunate that I wasn't able to act on this that desperate impulse. But what about other victims whose circumstances aren't so lucky? And when I sit here today and listen to these women, I realize that that could have been my mother, that she could have killed her abuser. And then where would I have been as a child growing up without my mother? Domestic violence victims are sentenced without being given a chance to provide evidence about their abuse, deserve another day in court. California is leading the way by having this great law in place and on the books. We are one of the only states that have this law. And so the California Partnership wants to work with the legislator. We want to work with organizations that are committed to making sure that we can do all that we can do to free battered women in prison. Thank you.
Thank you, Assemblymember Ma, and thank you to the Assembly's Select Committee on Domestic Violence for holding this hearing to address the issues facing incarcerated domestic violence survivors. DV survivors who are charged with and convicted of crimes are often forgotten by the rest of the anti-domestic violence movement, and I greatly appreciate this committee for taking the time to consider the challenges facing this unique group of women. My name is Marissa Gonzalez, and I'm a staff attorney at Legal Services for Prisoners with Children, where I manage the California Habeas Project. The Habeas Project is a statewide collaboration that seeks justice for unjustly incarcerated survivors of domestic violence. Our collaborating partners include the California Women's Law Center, Legal Services for Prisoners with Children, the Los Angeles Public Defender's Office, and the University of Southern California Law School's Post-Conviction Justice Project. The people we work with are incarcerated for crimes directly related to their experiences of being abused, but were unable during their trial proceedings to tell their stories or have a court truly understand the impacts of the abuse they experienced. Without expert testimony to educate the court and uncover the myths and misconceptions about domestic violence that many people still hold, these survivors were given unduly harsh sentences and continue to be incarcerated decades after their convictions. You've heard from Brenda and from Flazell about the realities experienced by battered women in prison, and you've heard from Dr. Lemon and Ms. Freeman about the ways in which California is allowing battered women charged with and convicted of crimes to present expert testimony on domestic violence to aid in their defense. Thanks to unique laws passed by the state legislature, California is on the cutting edge of efforts nationwide to understand the effects of intimate partner battering on domestic violence survivors charged with crimes. Since the enactment of Penal Code Section 1473.5 in 2002, the California Habeas Project has worked to make incarcerated DV survivors aware of the relief offered by this statute, to interview those survivors in prison and determine who may qualify for habeas relief, and to recruit, train, and support volunteer attorneys like Ms. Freeman, mostly from large law firms statewide, to represent battered women through 1473.5 habeas petitions and parole hearings. And you heard some of the reasons why we turn to the large law firms who have the resources to put into these cases. We receive letters from domestic violence survivors across the state asking for our help. Since 2002, we've screened over 100 people into the project and have found pro bono representation for about 65 survivors. An additional number have been represented by USC's Post-Conviction Justice Project and the LA Public Defender's Office. And I'm happy to report that as we approach our 10th anniversary, the efforts of the Habeas Project have led to the release from prison of 34 unjustly incarcerated women. While we continue to conduct screening interviews, we believe that we have identified the majority of survivors who qualify for relief under this law. We currently have 19 women who've been screened into the project and are waiting for legal representation. Some have been screened into the project for over 5 years, and they continue to wait to be paired with legal teams. These cases are resource intensive, as Ms. Freeman talked about. They require years of attorney efforts, investigating cases that are often decades old, tracking down witnesses, hospital records, police reports from years ago, hiring an expert on domestic violence to interview the survivor and issue a report, and writing a petition for writ of habeas corpus to file in court. On average, our legal teams have spent upwards of 4 years on each case. In today's economic climate, it's becoming increasingly difficult to find law firms with the capacity to commit these types of resources to pro bono work. And as you heard from Ms. Freeman, solo practitioners can be overwhelmed by the personal sacrifice necessary to represent these battered women. One of the most emotionally difficult things that I do in my job is to write back to women who've been waiting for over 5 years to be paired with legal teams and tell them that I haven't forgotten about them, their case is important to me, but I still don't have a legal team to give to them. As Professor Carrie Hempel points out in a 2011 American Bar Association criminal justice article, relief likely would have come to many women more quickly if the statute 1473.5 had included an appropriation of funding for the costs involved in litigating these petitions and or the creation of a statutory right to representation. providing for the appointment of counsel once petitioner has made a prima facie case would help to ensure that all those entitled to relief are afforded it. Without counsel, these women are unlikely to succeed with habeas petitions. In the past year, the Habeas Project was able to recruit representation for 3 domestic violence survivors. At that rate, it will take us over 6 years to find legal teams for the remaining 19 women, to say nothing of the women who may still be screened into the project in the future. These women would likely have been convicted of lesser crimes or not have been convicted at all had expert testimony on intimate partner battering been admitted during their original trial proceedings. Each day that they spend in prison waiting for a legal team to take up their cases is another day where justice is delayed. At some point, that delay in justice diminishes the justice once it's finally received. Additionally, while 12 domestic violence survivors have been released through these 1473.5 habeas petitions, another 20 have been released through the parole process while represented by Habeas Project legal teams. We believe that our clients have seen this kind of success with parole, which is fairly unusual in California, where we release so few people on parole, because unlike the majority of life-term prisoners who are represented by board-appointed attorneys, these women are represented by dedicated attorneys who have the time and the resources to get to know their clients, thoroughly investigate their clients' records, and pursue habeas petitions challenging board decisions when those decisions are not based on evidence that the domestic violence survivor currently poses a risk to public safety. In contrast, unfortunately, board-appointed attorneys are capped at $50 an hour for 8 hours of work on each client's case. And that's a time limit that barely covers the hours spent on the hearing itself and the travel to and from the prisons, which, as Ms. Freeman said, are pretty far away from where most of these attorneys work, to say nothing of the hours needed to properly prepare a client for the parole hearing. Unfortunately, there are 2 major problems with parole as an avenue for release for the domestic violence survivors we work with. The first is very practical. Some of the survivors that we work with are serving life without the possibility of parole. This precludes them from being considered for parole eligibility regardless of the horrific abuse they experienced and its relationship to the crimes for which they were convicted. Women like Rosemary Dyer, who's featured in the film Sin by Silence, killed her abusive husband after enduring years of unspeakable abuse at his hands, and she's unable to have that abuse considered by the parole board as a mitigating factor in favor of her parole because she's serving a sentence of life without. The second problem with the parole system is more nuanced. Since the 2008 ruling by the California Supreme Court in a case called In Re Chaputis, the Board of Parole Hearings has relied more frequently on a supposed lack of insight to deny parole. In the Chaputis case, Mr. Chaputis was convicted of murder for killing his second wife. He had a long history of domestic violence, including abuse against his first wife and allegations of molestation and rape by his daughters. Despite years of programming and a discipline-free record, while in prison, Mr. Chaputis refused to acknowledge the role that his history of abusing the women in his life played in the crime that he committed against his second wife. So the Supreme Court found that the Board of Parole Hearings and the governor could rely on Mr. Chaputis' lack of insight into why he committed this crime to continue to deny him parole. Since that ruling, we've seen countless battered women be told that they lack insight into their commitment offenses when they talk about the abuse they experienced to provide context for the crimes they were convicted of. Even women who have had their claims of abuse substantiated by the board's own investigations unit have been told that they are minimizing or denying responsibility for their crimes when they bring up the history of being abused in the context of the commitment offense, even though that history is supposed to be a mitigating factor in favor of parole. So despite the legislature's best intentions, battered women continue to sit behind prison bars serving sentences that would have been much shorter had their cases been heard today, with today's understanding of domestic violence. I would welcome the opportunity to talk further with members of this committee about specific strategies to address the problems that incarcerated domestic violence survivors continue to face, particularly ways for these survivors to access legal representation or avenues to resentencing. Again, I thank this committee for bringing attention to these issues, and I hope that this hearing might lead to increased support for the women who are unjustly incarcerated.
So I do have a question. You said that there are currently 19 screened and just waiting legal representation. Is there an ordering process, or or are they just first in?
I actually try to let legal teams, like Ms. Freeman talked about how Brenda's story had spoken to her. So I try to let legal teams have a little bit of information about each client, protecting their anonymity, and then whoever speaks to them, let them take that case on, because they are going to be putting in so much time and so many resources.
You had mentioned that it takes 4 years for a case, and I guess this is also perhaps a question for Ms. Freeman too. But I mean, how many hours of work usually? I realize each case is different.
Yeah, we try to survey our attorneys about it. One example is the case that I saw that took the shortest amount of time took about a year, and that attorney was at Morrison Foerster, and she told me that she was allowed to bill 85% of her hours to this one pro bono case. That's completely unheard of at most law firms. So most of our attorneys tell us about, on average, 50 hours a year, but they're often working in teams of attorneys. So for a team of 4 to 6 attorneys, each one is working 50 hours a year.
Good afternoon, Madam Chair and committee member. My name is Jean Jordan. I'm the Violence Against Women Act Director for the California District Attorneys Association. I've been a criminal defense attorney, a prosecutor, the director of a battered women's program, and a survivor of domestic violence. Currently at the California District Attorneys Association, one of my duties is to train prosecutors in California with regard to domestic violence prosecutions. These prosecutions present some of the most complex and challenging issues for prosecutors. We strive to train our prosecutors about the complex psychosocial dynamics that frame violent relationships. These dynamics, we know, are present in most of the domestic violence cases which we prosecute, and we know that they are also present in the case where a battered woman kills her batterer. But in those cases, the domestic violence dynamics may not be as obvious to the prosecutor. In a typical domestic violence prosecution, we have the opportunity to interview and talk with the victim, talk to their family, and collect evidence which supports their version of the events that occurred. When we are prosecuting, or a battered woman has been charged with a crime, we don't have that luxury. Once a person is arrested, they have a right not to speak to law enforcement, which of course would include the prosecution. Once someone is charged with the crime, the prosecutor is faced with relying on police reports and whatever information the criminal defense attorney may provide to the prosecutor. So some of the critical information that may have a very important impact on a case may not actually get to the prosecutor. What we know from working with domestic violence victims is disclosure is something that takes time. When I worked with domestic violence victims, both as a criminal defense attorney, as a prosecutor, what we know is it takes time. A domestic violence victim doesn't tell you their entire story the first time you sit down with them. And women who are charged with killing their batterers don't have the luxury of that time to build the rapport, the relationships, which it may take in order to end up in full disclosure. These cases where a woman is charged with killing her batterer often involve the most violent, horrific, and humiliating types of domestic violence, which the battered woman may be reluctant to share, at least initially, and they don't have time. They don't have time to wait. Because these relationships are often clouded in secrecy and isolation, there may not be corroborating evidence which can support the defense that the battered women may want to present. In the event that the prosecution does receive information about a violent relationship, then the decision about what to do about it is complicated. Is the evidence sufficient to support the defense? If it is, what, if anything, should be done about it? And we have to remember that generally it's a judge who decides whether or not the information is, the evidence is sufficient to support the defense being used in court. Prosecutors have ethical duties, and one of those is to present cases and prosecute cases that can be proven beyond a reasonable doubt. The decision as to whether or not someone is justified or should receive some mitigating consideration after they committed murder is not an easy one. It requires the assessment of many factors: evidence, the applicable law, and a look at the concepts of fairness and justice. And while everyone may not agree with the decisions that prosecutors may make in these cases, we hope that there's at least some general understanding that these cases are complex. These decisions are not come to lightly and are not easy for prosecutors. We constantly strive at the California District Attorneys Association to make sure that at a minimum our prosecutors have an understanding of these complex issues so that when the time to make these important decisions comes to them, they will do it well informed. Thank you.
Okay, so we're at the public comment portion. We wanted to leave plenty of time. We're going to ask Brenda and Flozell to come up and just start the public comment process. And then when they are done, we're going to allow time for members of the public to also make a comment if you so wish.
Awesome. I wanted to share a letter of a young lady by the name of Anna Gillinitz, who is still incarcerated. And I see so much of what happened to me in her. And it's a constant reminder that there are a lot of me still in there. And I think that at some point we should dedicate giving them an opportunity that I once had. I remember when I said I was not a bad person, and it was hard for me to convince someone of that who saw me as a convicted murderer. And I think seeing myself in this young lady, this letter represents that. Her name is Anna Gillinitz, and she says, being in an abusive relationship, it doesn't just happen overnight. It's a process. And I think the first part of that process, for me at least, was not thinking in my mind that I actually had value. I never actually thought I was someone who was worthy of being respected and appreciated. I was too worried about being the perfect girlfriend and not wanting to say anything, not wanting to say my views because I was afraid that I wouldn't be accepted or that I would possibly be abandoned. When I was arrested, I was 18 years old. The police officer kept convincing me that I would be okay, that they understand and that I was protecting myself and was just trying to make the abuse stop. I remember during the ride to the police station that the officer said if his daughter was in this situation, that he would 100% be on her side. My lawyer took me to trial after only 1 week of preparation. He didn't speak to me. He didn't speak to any of the witnesses. He didn't question anybody. At the time of my arrest, they took pictures of my bruised body, and it wasn't admissible. I've been in prison for the past 19 years. I've now lived in prison longer than I've lived out of prison. I am not a bad person. I made a mistake. Back then, I didn't feel that I had anywhere to turn to. I've taken the steps to pay my dues, and I will continue always for the rest of my life. I just want a chance to be free. I want to share my story with teens and help prevent them from making the bad choices I've made. I want to hug my mother before she passes away. I want the chance to prove that I have values and worth. I would like for her to have an opportunity to hug her mother, because I did not. Thank you.
I'm reading this letter to you today on behalf of Glenda Crosley. As an old woman of 67 years old, justice and freedom evades me. Although numerous laws have changed, I have not benefited and remain in prison, serving my 23rd year behind bars. In 1986, I defended my life when my husband started to attack me in a public parking lot. I was arrested and spent a few weeks in jail before my family could bail me out. I returned to my job and worked the entire time through both of my trials. I was tried in 1987. That resulted in a hung jury. And in 1988, I was retried again, and nothing about the trial went well. The jury was not allowed to hear my testimony or evidence of my abuse. I was kept from testifying and was found guilty, ultimately, of second-degree murder and sentenced to 15 years to life. I arrived at the California Institution for Women in 1988. I've served 23 years now and have had 6 denials at the parole board. I've had no serious write-ups. I have heart problems and have had to have several major surgeries. There's a lot of people in society that make it very hard for a woman like me who was forced to kill because of domestic violence to get out of prison. People cannot begin to understand that a person can be forced to defend their life is worthwhile. They cannot imagine that protecting your life matters. Nobody's saying it's acceptable. All we can say is, I've done enough time. I've gotten old in prison. I've learned from my experiences. I try to teach others. Don't I deserve some time out there at the end of my life? I'm not asking to be exonerated. I'm saying, when is enough enough? I've spent 23 years of a 15-year life sentence behind bars. I married him when I was 18. I'm 67 years old. How long am I supposed to remain in this relationship? It's the only one she ever had. I just ask to be able to move on and prove who I've become. I'm worth saving. I'm a worthwhile person. These are the women of convicted women against abuse. These are the women we represent today. There are many more that are still left behind. Hear our voices to be their voice. And again, I thank you.
Anybody else wish to make a public comment?
I'm going to borrow one of these for just a second. My name is Ann Karin Cleveland. I'm one of the producers of Sin by Silence. One of the reasons why that particular comment hit for me is that Glenda's now 67. When she first said one of those words, she was 61. And I kept thinking, when we were inside prison shooting, I kept thinking, this can't be possible. We can't. There has to be something wrong with these women's stories, right? And when we as citizens look at these stories, we say, that can't be, because we would never let that happen. We would never let that happen, right? So these women must be lying. There must be something wrong. And I tell you what, these women are amazing, incredible human beings who have changed now millions of young women's lives who will not do the same thing. And I just want to thank you for taking this on, because it's an incredibly important issue for our country.
Hi, my name is Karen Shane. I'm Policy Director of Legal Services for Prisoners with Children. I work with Marissa Gonzalez, and I visited, we spent many hours at prison. I spent a lot of time with Brenda at several different prisons in the state of California. And I just want to say that the two women who spoke here today really are representative of many women who are still doing time and who are literally languishing behind bars. It's a huge waste. It's a waste of their lives. It's a waste of our resources. And we can do better than this. And so I just want to give you my vow as part of Legal Services for Prisoners with Children. We would be happy and delighted to work with you on something to bring this to some kind of reasonable conclusion. Thank you.
Olivia.
Hi, I'm Olivia Klaus, the director of Sin by Silence. And today's really emotional for me. 10 years ago, I met these incredible women when I first started volunteering at Convicted Women Against Abuse. And from that first day, they completely changed who I am and how I look on this world. Because how is this happening? How have we let it get this bad? We're women who in a split second have to defend their lives, the lives of their children, and we punish them by throwing them in prison and throwing away the key. Over 20 years these women have spent in prison, and from that first day, they completely shattered my misconceptions that I had on domestic violence. They've taught me more than any expert in any textbook on this issue. And their stories are changing the world now through Sin by Silence. They're creating an impact that they have no idea how many lives they are saving. And it's our chance today to save their lives. It's our responsibility today to save them. And from that first day that I started volunteering with the group, these women changed me. They could be my mother. They could be my grandmother. They could be myself. Because any one of us could be put in that position to have to make that choice to defend ourselves. And I am just beyond thrilled to have these people and all these advocates and all these supporters here today to just present to you this crisis and present to you this injustice and what the system has labeled these women as offenders. I see them as victims, and we're continuing to victimize them. And it's time that we protest, and it's time that we do something, and it's time that we say to these women, you are worthwhile. You do have value, and you do matter. And your stories could be out there, just like Brenda and Flozell. They're saving lives. They're educating people. Yet we're keeping these educators behind bars. And it's time that we do the right thing and help these women.
Anybody else? Dr. Pan?
Well, I just want to thank all the people who presented today for your very moving and cogent testimony. And again, thank you, Assemblyman Ma, for leading the committee and having this hearing today. And so again, I want to thank everyone for their presentations.
Yes, thank you to everyone. This is emotional for everyone. When I first met Brenda and Olivia, you guys also changed my life. So, I am on this journey with you guys to try to get the women out of jail. So, that's what I do as a legislator. We try to change the laws and to level the playing field and bring justice. So I want to thank all of you for coming up and for all the time you served in jail. Not seeing your families. For protecting yourself and enduring a system that isn't fair. So I want to thank everyone for coming. I think, as you can see, we have a little bit of work to do this year. It is one of my top priority bills. I'm going to go and visit some of these women in the institution. I look forward to hearing their stories. If anyone would like to come with me and my office, we'd love to have you. Because the more people that understand and hear the stories, I think the quicker we will be able to get them out of jail. As we can see, it takes years to get legal representation. And the women that are waiting right now, the 19 women that are waiting, who knows how long they're going to wait. And so I'm committed to doing what I can. We're going to do the best we can to give these women another day of justice. So I look forward to working with all of you over the next 9 months. And again, thank you, everybody, for coming to share your story. I know it's not easy to talk about the past. I want to thank all the advocates for all the time that you spend, because we know it's not a 9-to-5 job. And to the filmmakers, Sin by Silence, thank you. They go around the country showing their film, trying to expose the situation and advocate on behalf of these women. And I want to thank you, ladies, for showing me the film, and Brenda for meeting you and telling me your story. So again, we look forward to working with all of you. And again, thank you so much for coming today.